By the time families discover financial exploitation, the damage is often devastating. Bank accounts are drained, property has been transferred, a retirement savings are gone, and the person responsible usually has an explanation. They wanted to give it to me. It was a gift. I was just helping. I am Michael Hackard of Hackard Law. For 50 years, I have built cases against financial exploiters throughout California. These cases are emotional, but winning them requires more than anger. It requires disciplined investigation, strategic evidence gathering, and a deep understanding of how California law protects elders. Under California's Elder Abuse and Dependent Adult Civil Protection Act, financial abuse includes taking or retaining an elder's property for wrongful use or with intent to defraud. The law protects anyone aged 65 or older. You do not have to prove the elder had dementia. The key question is whether someone wrongfully obtained or kept their property. Strong exploitation cases rest on three pillars. The first pillar is financial evidence. We begin with bank records, credit card statements, brokerage accounts, and property records. We look for unusual withdrawals, new names added to accounts, transfers in round numbers, checks written to the suspected exploiter, or sudden liquidation of investments. We trace funds. Where did the money go? Was it deposited into the exploiter's account, used to pay their debts, converted to cash? In complex matters, we work with forensic accountants who reconstruct financial timelines. They turn scattered statements into a clear story of what was taken and how. The second pillar is vulnerability evidence. Exploitation rarely happens in a vacuum. We review medical records for diagnoses of dementia, cognitive impairment, or confusion. We examine physician notes documenting memory problems or decision-making concerns. We speak with family members, neighbors, and longtime friends who observed changes in behavior. Vulnerability does not require legal incapacity. An elder can be legally competent, yet still susceptible to manipulation due to isolation, illness, or dependence on a caregiver. The third pillar is proof of wrongful conduct. We analyze the relationship between the elder and the suspected exploiter. Was there a confidential relationship? Did the person control mail, phone calls, or finances? Did they isolate the elder from family? Were transfers made during hospitalization or cognitive decline? Was secrecy involved? California law recognizes that when someone in a position of trust benefits from a transaction with an elder, a presumption of undue influence may arise. That can shift the burden to the exploiter to prove fairness. Let me share a composite example from a North Bay case. An elderly widow began showing cognitive decline. A caregiver was hired. Over several years, millions of dollars disappeared. Bank records showed escalating withdrawals. A home equity line was opened. Credit card charges appeared at locations the elder never visited. Medical records documented moderate dementia. Witnesses described isolation from family. Text messages between the caregiver and a family member revealed coordination. The case was built carefully, step by step. Funds were traced. Vulnerability was documented. Wrongful conduct was exposed. The court found elder financial abuse. Assets were recovered. Attorneys' fees and punitive damages were awarded. Justice required preparation. At Hackard Law, we follow a structured approach. First, we secure evidence before it disappears. Bank records, emails, medical files, and digital communications can be lost if action is delayed. Second, we build a detailed timeline integrating financial transactions and medical events. Third, we follow the money. Recovery depends on knowing where assets went and whether they can be reached. We also evaluate recovery realistically. Winning a judgment is not enough if there is nothing to collect. We identify all responsible parties, including caregivers, family members, agencies, financial advisors, or institutions that may share liability. For qualified cases involving substantial losses and clear evidence of exploitation, we offer contingency fee representation. That means families can pursue justice without upfront legal fees. There are warning signs families should not ignore: sudden financial changes, new individuals gaining control over accounts, isolation from loved ones, unpaid bills despite ample resources, an elder unable to explain recent transactions. If you see these signs, act quickly. The statute of limitations can limit your rights. Evidence can vanish. Assets can be hidden or spent. At Hackard Law, we have spent 5 decades building elder financial abuse cases across California. We understand how exploiters operated, how to dismantle their defenses. These cases require precision, patience, and strength. If you suspect financial exploitation, do not wait. Call Hackard Law for a consultation. Let us help you determine what happened, preserve the evidence, and pursue recovery. Vulnerable elders deserve protection, and those who exploit them must be held accountable. Hackard Law represents heirs and beneficiaries in estate and trust litigation in the San Francisco Bay Area and throughout California. You can call us today at 916-313-3030. We look forward to hearing from you.